Dear ladies and gentlemen, esteemed colleagues and experts in the field of child protection, dear children and young people. At the beginning, I would like to note that despite of my professional experience, this is my first major public address in front of colleagues, and I hope you will excuse a touch of positive stage fright. Now let us begin. Today, I will speak to you about one of the most significant institutions within the child protection system of the Republic of Croatia, the Center for Special Guardianship. The Family Act from 2014 mandated the establishment of the Center for Special Guardianship, and the Republic of Croatia holds the founding rights over the center. The work of this institution is often not very visible to the general public, yet its importance for the life and well-being of children is immeasurable. I would like to emphasize that based on its public authority, the key role of the center is to ensure that the children and adults are represented before courts and other bodies in accordance with the laws that govern family relations. However, as we gather here today to focus on the protection of children's rights, I will limit my presentation exclusively to that aspect. The Center for Special Guardianship, just a minute. The Center for Special Guardianship is headquartered in Zagreb and operates through 7 regional branches across Croatia, ensuring jurisdiction over the entire territory of Republic of Croatia. The center was established to provide professional, independent and objective protection of children's rights and interests in all proceedings in which parents, due to a conflict of interest or for any other reasons, are unable to do so themselves. It represents a safety net activated whenever a child needs someone to be exclusively their voice, their representative and their protector. The new legal framework introducing the Institute of Special Guardian for Child constituted a significant part of the reform of Croatian family legislation, initially resulting in the Family Act of 2014 and subsequently following the Constitutional Court suspension to that act, the adoption of the Family Act of 2015. On the aims of the reform was to strengthen the procedural position of the child in family court proceedings, ensuring that the child's procedural rights guaranteed under previous family law provisions and international documents, and effectively realized in court practice. The Institute of Special Guardian for Child in 2015 Family Act was modernized in line with the Croatian obligation under the Convention on the Exercise of Children's Rights. The Family Act of 2015 more precisely defines the representation of the child independently or of parental influence through the appointment of special guardians. It also establishes the explicit duty of court to enable the child to express their opinion in family matters, as well as the procedures for ensuring that this right is genuinely exercised. In fulfilling this right, the special guardian plays a crucial role. The clearly defined procedural mechanisms incorporated into the Act demonstrate the implementation of solutions from the European Convention on the Exercise of Children's Rights, whose purpose is not only declarative recognition, but also the effective practical respect of children's procedural rights by bodies deciding on children's matters. The Act therefore answers key question: in which proceedings a special guardian must be appointed, who may act as special guardian and with what qualification, and what the rights and duties of the special guardian are. An additional positive step forward was the adoption of the 2020 Act of the Center for Special Guardianship, which regulates the Center's status, activities, and internal organization. Professional duties in the center are carried out by a lawyer who has passed the bar exam, as well as social workers, psychologists, and the social pedagogues who have passed the respective professional examinations. The role of special guardian must be performed only by a lawyer who has passed the bar exam and has at least 3 years of professional experience in relevant field. Such a lawyer must also have specialized training in child and adult protection in proceedings before courts and other competent bodies, as well as the necessary knowledge and skills for communication with children and adults. Social workers, psychologists, and social pedagogues must have at least 3 years of experience in working with the children, and as well as additional professional knowledge, skills, and competence necessary for communication and obtaining the views of children and adults. Currently, the number of employed special guardians at this moment is 26. A special guardian represents children before courts and other authorities in accordance with the family law, especially in marital disputes and proceedings regarding the consultation or motherhood or paternity, other proceedings concerning parental responsibility, its individual elements and personal relations with the child in the case of a dispute between the parties. Proceedings involving protective measures safeguarding the child's personal rights and well-being. Proceedings on decisions substituting parental consent to adoption. Property proceedings or disputes, as well as when entering into the certain legal transactions where a conflict exists between the child and their legal representatives. Cases of international child abduction and other instances provided by the legislation governing family relations. Whenever a child becomes the subject of court proceedings, a special guardian is appointed either by the court or by the Croatian Institute for Social Work. Article 414 in Family Act defines the legal position of the child in judicial proceedings as follows. The child is a party in all proceedings in which parental responsibility, personal relation with a parent or child support are being decided. Parents are not authorized to undertake any procedural actions on behalf of the child alongside the special guardian. The special guardian establishes a direct contact with the child, informs the child about the guardian's role, the subject matter of the court proceedings, and the child's rights to express their opinion. The guardians explain possible consequences of the child's expressed views and, if necessary, speaks with both parents, all in accordance with the guardian's statutory obligation under Family Act and Article 10 of the European Convention on the Exercise of Children's Rights. The regulation on the manner of obtaining the child's opinion prescribes the method of obtaining the child's view depending on his age, the person authorized to speak with the child, and the procedure for obtaining for child's view, and the requirements for the location in which the conversation is conducted. Information provided to child, whether written or oral, must be adapted in content and form to child age and level of understanding. The child must be able to express their opinion freely and without pressure, and must be able to choose whether to express it directly or indirectly. The child must not be manipulated or subjected to inappropriate influence to another person. Conversation must take place without the presence of parents or any individuals who might be in conflicts of interest with the child. It is essential that the child is interviewed only as many times as absolutely necessary, especially in cases involving traumatic events, to avoid further distress. Another key element is ensuring an appropriate and safe environment for conversation with the child. The role of the special guardian is to represent the will and the best interests of the child, and to fulfill this role professionally, responsibly, and in full compliance with the law. The focus of the special guardian is always the child, not the expectations of or desires of the parents or any other persons. In communication with the court, the guardian must be articulate and present the child's views. The guardian acts as a vital link and bridge between the child and the court. A guardian must possess personal aptitude for this role, and given the evolving understanding of children's rights and the societal need for special protection of children, but also possesses both specialized legal and non-legal expertise. When determining the child's view, it is crucial that the guardians faithfully conveys the child's will to the court. All participants in the proceedings must recognize enabling the child to express their views in an integral part of the judicial process and of the best interest principle. The special guardian fully represents the child and actively participates in the proceedings by submitting statements, responding to petitions, commenting on submissions, filing appeals, revisions, constitutional complaints, and requesting information from institutions regarding actions taken for the child's welfare. The cases, as they are often called, are in fact human lives, realities many of us cannot imagine. Special guardians frequently emphasize that the experience they have gained in this work has shaped them personally, giving insight into a very different world, one of struggle, care, empathy, but also immense hope and trust in the system. Throughout their work, special guardians participate continuously in professional development through trainings, workshops, and conferences in the field of family and child protection. The Social Welfare Academy plays a particularly important role, continuously monitoring the center's need and organizing specialized trainings accordingly. When discussing child rights protection, it's important to highlight that Croatia, through the Center for Special Guardianship, has made significant progress in strengthening institutional protection. This system is aligned with the international documents, primarily the Convention of the Children's Rights, ensuring that the child is not merely a passive object of these proceedings, but an active participant whose voice and needs are being respected. Of course, like any other system, this one also has to continue to grow and involve the needs of children and families change over time, and with them the demands placed on institutions. It is vital to invest in additional training for special guardians and, more importantly, in strengthening in the center's staffing capacities to reduce the workload and improve accessibility and overall quality of service. It should be noted that in 2024, the total number of child-related cases in which a special guardian was appointed was 5,494, while the total number of children involved in these proceedings was 8,370. Therefore, our task as a society and as a professional is to continue supporting the center, strengthening and further developing it, and working together to ensure that every child in Croatia is protected in the best and the most effective way possible. Thank you for your attention, and thank you for helping us build a system that places the child first.